Good morning, good afternoon, and good evening to everyone joining us from around the world. On behalf of the International Association for Court Administration, IACA, I am delighted to welcome you to today's webinar entitled Trauma and the Administration of Justice, Integrating Research, Judicial Practice, and Court Leadership. I would like to begin by saying we are especially grateful to our Pravo-Justice colleagues for their partnership and leadership in assisting with many webinar events over the past 3.5 years. Thank you. Of course, we are also honored and very grateful to our outstanding panelists for sharing their expertise and experience in today's session. At a time when court systems around the world are confronting unprecedented challenges, the experiences and insights emerging from Ukraine and many other countries offer lessons that extend far beyond national borders. They remind us that courts are not only institutions of law and justice, they are communities of people who carry immense responsibilities, often while navigating extraordinary personal and professional pressures. The administration of justice has always required resilience. Judges, court leaders, and court staff are called upon to make difficult decisions, manage complex caseloads, and serve the public with integrity and impartiality. Yet, in recent years, the demands placed upon court systems have intensified. Global crises, armed conflict, natural disasters, and social upheaval have highlighted a reality that many court professionals have long understood. Exposure to trauma, chronic stress, and human suffering is not peripheral to the work of courts. It is often embedded within it. For many years, conversations about judicial excellence focused primarily on legal knowledge, procedural fairness, and organizational effectiveness. These obviously remain essential. However, there's a growing recognition that the well-being of court personnel and judges is equally important to the long-term health and effectiveness of our judicial systems. A resilient court system depends upon resilient people. Today's webinar brings together distinguished experts and practitioners from Ukraine, Australia, and the United States to explore this critical topic from multiple perspectives. We will examine the latest research on trauma and well-being, discuss practical strategies for court leadership, and consider how institutions can create environments that support both professional performance and personal resilience. One of the strengths of this program is its interdisciplinary nature. Our speakers represent scholars, judicial leadership, court administrator, as well as practical experience. Together, they demonstrate that supporting well-being is not solely an individual responsibility, it is also an organizational responsibility and a leadership responsibility. Effective court leaders must understand how trauma affects people, teams, and institutions, and they must be prepared to foster cultures that promote emotional safety, professional support, and sustainable performance. This conversation is particularly timely because the challenges we face are not temporary. Courts around the world are increasingly being asked to operate in environments characterized by uncertainty, complexity, and continuous change. Continuous change. The question is not whether stress and adversity will affect our institutions. The question is how we can respond in ways that strengthen our capacities to serve the public while caring for the people who make that service possible. So let us begin our program and explore together how research, judicial practice, and court leadership can contribute to healthier, stronger, and more resilient justice systems. You will find an information link in the chat box to a publication by the National Center for Safe Courts entitled Workplace Wellness. At this time, I would like to introduce today's moderator, Dr. Giuseppe Fazzari, who is a professor of criminal justice at Monmouth University and who is also a former chief administrator and court executive serving the New Jersey judiciary. He is an author of many publications, including an upcoming comprehensive book on court administration, soon to be published. Dr. Fazari also serves as IACA's Vice President for North America. Dr. Fazari, please lead us into today's learning opportunities. Thank you.
Thank you, Pam, and for that warm welcome, and welcome everyone. Good morning, good afternoon, good evening to our global friends and colleagues, no matter where you're joining us. So we have some additional opening remarks. I'd like to introduce the head of the State Judicial Administration of Ukraine, Maxim Pampura.
Шановні колеги, партнери.
Dear colleagues, partners, participants of the webinar, the topic for discussion is very important in the light of the existing conditions since Ukraine is in the middle of the fifth year of the war. Many Ukrainian citizens suffered displacement, loss of families and relatives. Many of them found themselves in very complicated life situations. All these cannot but exercise impact on the operation of courts and people who are working in courts. Today, Ukrainian judicial system face multiple challenges. Ukrainian judges have to deal more and more often with cases where trauma is present. At the same time, court staff members and other justice sector representatives have to operate in the conditions of constant stress and trauma. That is why understanding trauma, understanding its consequences on people's behavior is very important for proper administration of justice these days. As one may know, a couple of years ago, together with our American partners, we've started a pilot project on establishing units for support of victims and witnesses in Ukrainian courts. The pilot was very successful, and we are trying to roll out this positive experience across the country. We understand that trauma-oriented approach is fully in compliance with proper administration of justice, principles of impartiality and unbiased approach. A lot depends on the leadership of courts. A modern leader is not only a professional in the field of law, but somebody who can ensure stability and uninterrupted work in courts, because courts are there to provide people with uninterrupted access to justice. Our today's webinar is yet another opportunity to discuss trauma-oriented approaches and best practices in the field of administration of courts in extremely complicated situation. I'm sure that we will find some very practical, we will hear some very practical solutions here. I wish to all the participants a very productive work. I wish everybody picks up something which would be very useful and practical, implementable in their work. Thank you.
Okay, Maxime, thank you so much for that. Our next speaker for opening remarks, a pleasure to introduce Oksana Simbrivska. She's the team leader of the EU Project Pravo-Justice. Oksana?
Шановні колеги, доброго дня. Для мене дуже велика честь
Dear colleagues, it's a great honor for me to welcome you on behalf of the EU Project Pravo-Justice. Today we have gathered to discuss a topic that just a few years ago was scarcely mentioned in discussions on judicial reform and court administration. Traditionally, we've talked about independence of courts, efficiency of procedures, digitalization, use of AI, integrity, access to justice, etc. However, today, the war and the full-scale invasion, which has been lasting for 4 years, for almost 5 years now, has reminded us of a fundamental truth. Justice is delivered by people. Behind every court decision, behind every case, and every court hearing are judges and court staff members who are also experiencing loss, who face challenges in the guise of air raid alerts, who face forced displacement, prolonged stress, and uncertainty. At the same time, it is judges and court staff members who ensure day in, day out the continuity of the judicial system and the implementation of the right to a fair trial. That is why the issue of the psychological well-being and resilience of court staff can no longer be regarded as something secondary or a purely personal matter. It is a question which is directly linked to institutional capacity and quality of administration of justice. For the European Union, a people-centered approach is one of the key principles of modern justice. We are increasingly talking not only about how the courts operate, but also about how the people who work in courts feel. That is why for EU Project Pravo-Justice, it was extremely important to have to support the first nationwide study on psychological well-being of court staff in wartime conditions, which will be presented today. What is extremely particularly valuable is that this study not only identifies problems, but also helps to understand which support mechanisms are effective and which managerial decisions can help the judicial system better respond to the challenges. This is indeed very important because on the one hand, we have this opportunity to come up with some Ukrainian solutions, but also to adopt some of international best practices. Ukraine is currently operating under the unique conditions of a full-scale war. At the same time, some issues such as professional burnout, secondary traumatization, psychological strain, and others are relevant to judicial systems worldwide. This is why the international exchange of best practices is of the utmost importance. And in the light of the above, I would like to thank our partners from the International Association for Court Administration for the long-term partnership we've been having during all this time. I'm grateful to the State Judicial Administration of Ukraine, to all Ukrainian Association of Court employees, and to all those who have joined and are there to share their knowledge and skills and best practices. I'm convinced that today's discussion will contribute to better understanding of how we can be more resilient and supportive. Thank you very much for your attention.
Oksana, thank you so much for that. So just a couple of housekeeping items before we begin, and then I'll begin to introduce the session as well as our esteemed speakers. So there'll be an opportunity for a Q&A session with the panelists at the end of the session for a few minutes, and then I'll have some closing remarks following that. So if you have any questions, place those questions into the chat and I'll review them and I'll submit them to our panelists. So, and with that, so the administration of justice and the sort of focal point of this webinar is often viewed through the lens of law, procedure, institutional performance. Yet at the same time, we have to recognize that the courts are also human organizations. So every single day that judges, court staff, attorneys, professionals across the justice system, we're constantly encountering individuals whose lives have been profoundly affected by violence, by abuse, loss, conflict, and in some of the worst instances in the examples, some of the opening remarks mentioned, is a large-scale crisis in terms of what Ukraine is going through right now, as as a result of the war. And so repeated exposure to these elements, the repeated exposure to trauma, obviously has certain significant implications, not only on those who are coming to the court seeking justice, but just equally as so for those professionals, such as those judges and court staff who are entrusted in delivering that justice that they're seeking. So today's webinar brings together an exceptional panel of experts who are going to explore for us trauma from a multitude of perspectives. And those perspectives are going to include psychology, it's going to include judicial practice, it's going to include court leadership, and the experiences of courts operating under some of the most extraordinary circumstances. Again, some of the examples provided in terms of what Ukraine is currently experiencing. So together, our panelists are really going to help us better understand how trauma affects, again, not just those court users, but also those justice professionals. And what practical steps, how can we address this pragmatically as a court to build a healthier, a more resilient institution? So with that, it's my pleasure to introduce our distinguished panelists. Our first panelist is going to be Dr. Carly Shriver. She's a lawyer, psychologist, researcher, and director of Human Ethos, Wellbeing for Judges and Lawyers. She's internationally recognized as a leading authority on judicial well-being. Dr. Shriver has advised courts and legal organizations throughout Australia, Asia, Africa, North America, the United Kingdom, as well as the Pacific. So basically all over the world. Her presentation in particular is going to examine psychology of traumatic stress and how exposure to trauma affects those who are working within the court systems. Our second speaker is Natalia Korol. She currently serves as the head of court staff for the Vinnytsia Court of Appeal in Ukraine. She's got more than 2 decades of service with the Ukrainian judiciary. She's widely respected for her leadership in court modernization, institutional resilience, and trauma-informed justice reform. Today, she's going to be sharing some insights from a national survey examining the well-being of court personnel operating again under those extraordinary pressures of wartime conditions. Our third speaker is Judge Selena Solis, who's the presiding judge of the 243rd Judicial District Court in El Paso, Texas. In addition to her judicial responsibilities, the responsibilities, the judge serves on the Judicial Commission for Mental Health and presides over INSPIRE, which is a felony mental health treatment court. She's going to be drawn upon her myriad of experiences on the bench, and Judge Solis will discuss the effects of repeated trauma exposure that occurs on judicial decision-making and the importance of trauma-informed judging. Our final speaker today will be Tina Madison. She is the immediate past president of the National Association of Court Management and a retired deputy court administrator with extensive leadership experience in California and Arizona courts here in the United States. Her work has focused on organizational leadership, strategic planning, staff development, as well as well-being initiatives, among other areas of study and practice. Ms. Madison will address why trauma-informed administration is not simply a personnel issue, but an operational imperative for courts, seeking to effectively serve the public while also at the same time supporting their workforce. So we're really extremely fortunate to have this accomplished and diverse group of speakers joining us today. It's really my distinct honor and pleasure in introducing them and moderating the session. So at this time, it's my pleasure to turn the program over to our first presenter, Dr. Shriver.
Thank you so much, Joe. Just allow me to share my screen. And hello, everyone. It's a real pleasure to be joining you from Australia, where we click over to midnight shortly, but I know it's a different time where the rest of you are. My portion of our panel discussion is to really share some knowledge from psychology, particularly the definitions of different kinds of traumatic stress, and tell you a little bit about what has been found in empirical research with the judiciary, in particular from Australia, but also talking a little bit about research from other parts of the world as well. So starting with a definition of trauma, there are a number of definitions, but this is one that I think is particularly useful. Trauma refers to an event or a series of events that overwhelms an individual's capacity to cope, resulting in disruptions to emotional regulation, cognition, and psychological arousal. What we can take from this definition is that trauma, what is traumatic for one person may be different from what is traumatic for another person. So we cannot define trauma by the event itself, but rather by the impact on the individual's ability to cope. Now, when we're thinking about traumatic stress in courts and within the judiciary, typically we've been thinking about secondary trauma. So the trauma that court personnel and the judiciary experience as a result of being exposed to information about the primary trauma of others. But I'm really conscious in this particular webinar, and particularly following on from the opening remarks of our two Ukrainian speakers, that very often, and particularly in Ukraine at the moment, judges are not only experiencing secondary trauma, they're also experiencing primary trauma. And so I want to hold that very much in mind. To give some definitions now about vicarious trauma. Vicarious trauma can be seen as one empathy-based stress reaction, and there are a number. I'm going to bring up some terms here that you might be familiar with. Vicarious trauma, secondary traumatic stress, compassion fatigue, and burnout. None of these terms are diagnosable mental disorders. However, secondary traumatic stress is now a pathway to a diagnosis of post-traumatic stress disorder. But these have really evolved in the occupational wellbeing literature across a range of different sectors and professions. So to give the official definitions of each of these experiences, vicarious trauma is defined as disruptions to a person's beliefs about safety, power, independence, esteem, intimacy, and frame of reference as a result of being exposed to another's traumatic experiences. Secondary traumatic stress refers to the development of PTSD symptoms, so symptoms of post-traumatic stress disorder, such as re-experiencing, that is, having intrusive images, nightmares, sensations, arousal, feeling keyed up or on edge, avoidance and emotional numbness following the traumatic experience of somebody else. Compassion fatigue refers to the reduction in the capacity or interest in being empathetic towards others, believed to result from the ongoing expenditure of empathy. And burnout refers to the presence of emotional exhaustion, cynicism, and feelings of disconnection from others resulting from prolonged work and interpersonal demands. So from these definitions, you can see how these experiences relate to each other, also how they're different. But they all come under this broad umbrella of empathy-based stress reactions. So to say something about how empathy-based stress works, we start with features of our context or our environment. And if we're thinking about court work, we're thinking about features of the court environment. And then also individual factors, features of our own demographics, histories, personality, coping style. These come together to determine the extent of the secondary trauma exposure we can have in our work and the degree of empathic engagement we will have with that secondary trauma exposure. Where the exposure is high and the empathic engagement is high, this is where it can lead to empathy-based stress in the form of compassion fatigue, secondary traumatic stress, and vicarious trauma. And when there is insufficient time, resources, support to metabolize, understand, and recover from this empathy-based stress, this is when it can lead to adverse outcomes for our work and also our health, including our mental health. So we can see from this psychological model that it is actually empathy, that very core, very important, very necessary human quality that we very much value in ourselves and that we very much rely upon in order to do our work with humanity and with a sense of meaning and purpose. That means that we are all vulnerable to empathy-based stress, including vicarious trauma, in trauma-exposed work, which the courts certainly is. Some of the warning signs and potential impacts of empathy-based stress include physical symptoms such as feeling heightened or changed arousal levels, so feeling kind of jumpy, easily startled, more irritable, feeling very, very tired or having sleep disturbance, and also noticing that our immunity is weakened, that we are picking up illness and not recovering from illness as quickly as we normally would. Behavioural warning signs include avoidance, so wanting to avoid certain reminders of the traumatic material we've been dealing with, certain kinds of cases, avoiding social interaction, and also finding it difficult to separate work from home, so finding that work is intruding when we're no longer in our work role. Psychological symptoms include re-experiencing events or images, so having thoughts and images intrude when we're not actually working on the case. Having changes to our core beliefs about ourself, others, and the world that enable the world to feel predictable and safe. Feeling more emotionally reactive, or the opposite, feeling cut off from the full range of human emotions. And this can have a range of impacts on how we work as well. So we can avoid responding to emails, calling people, certain kinds of cases, find it difficult to concentrate, rely overly on macabre humour as a way of coping. This can all lead to reduced productivity and efficacy in our work. We can feel disconnected from the human value of our work and start to become cynical, a loss of a sense of meaning and purpose. And at times we can be more emotionally reactive, leading to conflictual interactions at work or unprofessional behaviour. A number of studies around the world have explored levels of vicarious trauma within judicial work, and I'm going to highlight some statistics that have come out of Australia here. In my PhD research involving judges from 5 Australian courts, I used a validated measure of secondary traumatic stress. And what I found was that almost 84% of judges reported experiencing at least one symptom of secondary traumatic stress in the week prior to completing the survey. And a staggering 30.4% scored above the cutoff on this validated measure that is suggestive of active PTSD. I was very staggered by the statistic, but some years later, a team of researchers from another Australian state did an independent study using a completely different validated measure of traumatic stress. And they also found around 30% of judges scored above the cutoff, suggestive of PTSD, with 22% scoring above the cutoff, suggestive of traumatic symptoms strong enough to suppress immune system functioning. And when we compare this to the population prevalence of PTSD in Australia, being only 5%, we can see how elevated PTSD symptoms are among the Australian judiciary. And where this has been studied in other courts in other parts of the world, similar statistics have been found. Now, traumatic stress, vicarious trauma, can occur in one of two ways. It can occur swiftly, for example, when we witness a horrendous accident or attack. But the more common pathway for judges and court staff is the cumulative impact, where repeated exposure to the details of trauma and the traumatic and disturbing experiences that people have gone through builds up in our unconscious mind, subtly changing our beliefs about the world and our beliefs about safety. And I've got a beautiful quote here from a Supreme Court judge in Australia that speaks to this cumulative impact. She said, "Each day you go into court and there's sadness, there's extreme sadness, and there's damage. And it's people struggling to have their rights protected who are damaged. And I feel very sad. You don't bring it into the courtroom with you, but you feel it." And what we know from research in other sectors, particularly research with first responders, such as police and ambulance officers, is that this cumulative impact can occur in the background without professionals necessarily registering the change that it is enacting upon them. But then what people often report is that there will be a case that has some detail of personal significance or personal relevance. Perhaps the child in the case reminded them of their own child, or there is a place or a date or a name of personal significance. And this element of personal relevance leads the professional to not only have a degree of empathic engagement with the case, but to go one step further and start to identify with the story that they are hearing. And when this happens, this can often be the trigger that means the cumulative impact is felt very rapidly. And because vicarious trauma is defined as disruptions to our core beliefs about the world, for many of us working in the justice system, particularly judicial officers and court administrators, one of our core beliefs is a faith in the justice system. We know that it's not perfect, but we have basic faith that it delivers on its promise most of the time. When vicarious trauma begins to affect us, we can lose faith in the justice system within which we are working. This can make it very hard to continue to do the work. And this leads us to possibly a more profound, maybe the most profound aspect of empathy-based stress that legal professionals and judicial officers can face. And this is known as moral distress, which is defined as the psychological, emotional, and physiological suffering that occurs when people are unable to act in accordance with their core values, ethical commitments, or professional responsibilities. And I know in my research, particularly in my interview research with Australian judges, the number one source of stress that judges emphasised was when they felt that they were presiding over an imperfect justice experience in the courtroom due to a range of systemic limitations and failures that were beyond their control. That was experienced as the most distressing form of occupational stress for the judges in Australia. So I think we can conclude that empathy-based stress is an occupational hazard of judicial work, which can make many judges feel caught between a rock and a hard place. And here is a quote that speaks to this tension that I think many judges and court administrators feel. Now, there are two things that can happen to you. Either you're going to remain a decent person and become terribly upset by it all because your emotions, because your feelings are being pricked by all of this constantly, or you're going to grow a skin on you as thick as a rhino, in which case I believe you're going to become an inadequate judicial officer, because once you lose the feeling for humanity, I don't believe you can do the job. And I wonder if that's something that those listening have contemplated, whether it feels like a choice between two options, neither of which feel palatable. In psychology, though, we know that there is a third way, and it involves recognizing that there is a continuum of involvement that we can have as professionals with the suffering of those that come before us, and finding strategies to stay within this ideal range where we have a degree of empathic engagement but maintain professional boundaries so that the work is sustainable. And before I finish up, I just want to highlight 3 ideas for how we can stay in this ideal range between over-involvement and under-involvement in the stories of the people that come before us. I know later in our presentation we'll be hearing about some of the organisational and systemic strategies that courts can put in place, and that is very, very important. Just 3 overarching principles for individual strategies that judges and court administrators can employ. The first is to recognise that exposure itself carries the greatest risk or the greatest hazard of vicarious trauma. So where possible, we reduce exposure. We don't read things multiple times if we don't have to. We don't read the whole document if the information we need is only in a certain part. Secondly, that preparation is key. Surprise exposure is much worse. So if we can prepare ourselves and get our mindset prepared to before we are exposed to some of the most difficult details of cases, that is much better than when it comes upon us in an unexpected way. And finally, that when we do find ourselves impacted by something we are reading or hearing, having strategies, and that there are many, many strategies, breathing techniques, grounding techniques to bring down our nervous system arousal quickly. This is the best way of ensuring a healthy trajectory out of the impact of traumatic exposure. So I'll finish there, and I look forward to hearing from the rest of our presenters and answering any questions at the end. Thank you, Joe.
Dr. Shriver, thank you so much. That was exceptional. Thank you for that. Our next speaker, Natalia Corral. I hand the program over to you.
Вітаю всіх. Дякую за запрошення, за можливість поділитися.
Good afternoon. Thank you very much for having me here. Thank you very much for allowing me to share information about what is currently happening in court apparatuses across Ukraine. So I will not make long introductions. I will go directly to my presentation, and I'll try to cover some key aspects which will be of interest for court staff present at this event and to all other participants. So I'll start my presentation by saying that in June, we're going to complete a project which we've implemented together with EU Project Pravo-Justice. I'm extremely grateful to Pravo team for supporting us on the way. And the the project was entitled "A Rebooting of Judicial System through Implementing New Solutions." When it comes to solutions, we meant solutions to provide greater access to justice, even to those categories who might encounter particular troubles, particular difficulties in actually getting access to justice. So this is basically about client-orientedness and about the court's capacity to provide a variety of services to all Ukrainian citizens despite war repercussions. It's been also about the courts being able to implement a human-centered approach, interacting with court users, with court clients, despite the fact that court staff members are exposed to stress, to trauma. One can often hear a court staff member saying, "We are tired of war. We are really tired." But if we look into the findings of our survey, one may find out that it is not only about personal aspects, about people being tired of war, but about some very objective risks which may jeopardize the functioning of an operation of the judicial system because of the excessive workload, because of some objective difficulties caused by law. So I would like to make sure that my presentation, the slides in my presentation are changing because it is important for you to see figures. If not, please let me know. So we've held a survey which with among some 400 respondents. This is not a lot, but this is enough. So we've sent out Google Forms for potential respondents to fill them in. The feedback was quite quick, which made me feel very optimistic because, again, considering the workload, one can expect that court staff members receiving yet another form to fill in, even though the idea of sending out these forms is to improve the operation of the court system as a whole and to make life easier and better for court apparatus. Despite all this, one may expect people be rather upset and not very much willing to respond and to fill in this yet another form. But the feedback, as I told you, came in quite fast, and we were pleased to find out that the whole variety of court staff members responded, starting from judicial assistants and up to secretaries of court sessions and registrars. 85% of respondents acknowledged the workload to be above normal. Natalia, our apologies. We cannot see your slides. They are not changing. Yes, thank you very much for letting me know. This is important for you to see the slides because there are some figures there. How about now? Can you see the slides now? Yes, we can see this slide number 2. I will now try to switch on. We're still on slide number 2, and this is slide number 3 now. So if this view is comfortable for everybody, I will continue like this, but I cannot have the slide in full screen mode. But it is a compromise to have it like this, because I really want you to see the figures. So 85% of respondents reported the workload be above normal, about acceptable. So many of respondents told that they have to work often extra hours, and it is not about working extra hours on some occasional basis, because there are some special investigative actions to be authorized or something else, but this is just a regular mode of operation. Having extra hours almost every day, and there is no compensation for these extra hours. There is no flexibility offered as um, compensation. This is because the workload is high, and because the courts are trying to meet the expectations of court users, which is the court to respect procedural deadlines, but it results in court staff members being absolutely exhausted and burned out. When implementing the project that I mentioned on the implementation of some model court solutions, Mr. Pampura mentioned that in his introductory speech. So within that pilot project, some SOPs for the treatment of vulnerable victims and witnesses. So these SOPs for vulnerable victims and witnesses were developed. It comes to victims and witnesses of violent crimes, of domestic violence, of some atrocity crimes, and others. So when developing those SOPs, we contacted, we reached out judges across Ukraine, judges and court apparatus members, and all of them were in favor of introducing such SOPs, but all of them also had a question how they were going to recover after providing such support to vulnerable victims and witnesses, and many people reported being ready to quit.
The war is a factor of professional stress. As I mentioned, a lot of people are overworked. They work in conditions of complete uncertainty. Nobody knows what's going to be the beginning and the end of their working day. 78% indicated significant impact of the war on work. All court staff members work in war conditions, and we cannot speak of any percentages here. No matter the region in Ukraine, missiles can reach any location, and there is no limited trajectory, so everybody faces this impact of war. Meanwhile, 34% of those who were surveyed said that they have access to fully equipped shelters, but 65% say that they cannot work from shelters. And even it's a court of appeal, the chief of staff of which I have been for over 10 years also has a shelter. And from my own experience, I can say why working in the shelter is very difficult. In the shelter of the Venezuelan Court of Appeal, we have a court room with all the required elements and equipment that we need to administer justice. But all of you should understand the practical factor of the use of this room. So the air raid alert starts. We are hearing criminal case, so we have to suspend the hearing. At least we need to put a pause on the video recording. Everybody has to go into the specially equipped room that is located on our ground floor. So we all need to readjust this equipment. Everybody should be properly seated in a room that is 3 times as less as the one that was used before, and everybody comes down to the court hearing place, to that courtroom. So it doesn't have the space where everybody can sit comfortably. So it is a factor of extra stress, and instead of focusing on work, trust me, everybody is chatting in order to be able to understand the trajectory of the missiles and the shaheds. So everybody's keeping uh, up with the current news. But when we speak of some massive attacks, I completely share the opinion of the 65% of court staff members that say that it's very difficult to work in a shelter even though it's there. 26.6% here it's where secondary traumatization comes in. So they work with traumatic case categories. Trust me that even work with domestic violence victims is traumatizing. It's hard for me to imagine how you can communicate and not be exposed to trauma if we speak of war crimes, and talking to the victims and witnesses in this category of cases. And 38%, a little bit over 38%, mentioned that they have all the signs of such secondary trauma. Of course, we can proceed with numbers. But now I'd like to list the categories of court staff who are most exposed. It's assistant judges. Right now, we are cooperating with the within the projects that are aimed at helping develop such court staff as judicial assistants and court secretaries, because secretaries and assistants and the people who work in the judicial office directly chair this anti-rating, so they are the top at the top of the charts. Also, the ones that are facing critical workload and experiencing the most severe shortage of staff. So when we speak of traumatic cases, my presentation looks very sad, but I'd like to say that the only paragraph from the whole analytical report that I read through several times, one paragraph really encouraged me and cheered me up, because 53% of those surveyed say that they feel that they do something that makes a difference, and they are part of the system because they feel that they have this important mission to execute. And what's important among those surveyed 250 people are those working in the system for over 10 years. And that is extremely hopeful, because they say that they are doing something useful, and they are ready to keep up this systematic nature of work and to be able to show resilience. And we hear that 70% of them can say that they are tired, and that it is also a good indicator given all the absolutely unfavorable and totally gloomy data that I have listed. Of course, our well-being is not only about care, and it's not only about reconstruction of Ukraine and some me time after work. So, as we see, it is a matter of the continuity of justice. Therefore, number one priority here is to sustain the HR capacity, and out of the proposed solutions, of course, there can be no fast solutions, but I can see among these approaches proposed by court staff members, something that they like to have is to have some time to recover and to be able to have some flexible working hours. So we can make sure that indeed some tailored approaches can be provided. But the first problem there is huge workload, and the second problem is no staff retention. So the analytical indicators show that some measures need to be taken, and I truly hope that next time at our next webinar, we'll be speaking of the proposals that we are suggesting to be implemented in the court staff, because today over 60% of the people say that their source of energy is family, humor, and such informal communication. So this shows that there is no place here for institutional approach. We don't have institutional policies in courts, which is bad. 58% of the surveyed said that they don't have these policies, and this is not an agenda item at all. So we have something to work on. I thank you so much for this platform, for this invitation to be speaking here so that we can develop what our courts truly need. And I can only thank for an opportunity to be able to present it. And I'd like to thank all the members of the court staff in Ukraine for the fact that they feel this mission and they try to stay strong even under such conditions. Thank you so much.
Natalia, thank you so much for that very comprehensive study and your remarks. Very noteworthy kind of study and findings that you've shared with us. So our next speaker now, it's a great pleasure to introduce the Honorable Selena Solis. Judge, the floor is yours.
Thank you. And I am, to honor the spirit of our time constraints, I have a timer going on. First, I want to let everyone know that it's an honor to participate in this discussion on trauma and administration of justice. I feel like listening to our presenters so far, I feel I wasn't surveyed by either of them, but it makes me feel good in a way that this what judges experience is global. I mean, it's not just confined to Texas or to the United States. So let me just real quick, I want to see if I can share my screen. All right, here we are. I hope, can y'all see what I'm showing or no? Yes?
No.
Okay. No? Okay, darn it. Let me see.
No, we can't, Judge.
All right, just I'm trying to share. Okay. Oh, how's that? Share? Can you see that?
And we can now, Judge. Thank
All
you.
right. So just for context, I am an elected judicial official in the state of Texas. And one of the, in my role, I have a non-adversarial specialty court, and it is specifically for adults that have been charged with committing felony crimes. And it's a specialty court because it's non-adversarial and it's a problem-solving type of court. And so y'all can understand where we sit. If you see, there's Texas at the bottom of the country, and then I don't know if you can tell where I'm pointing, but along to the most western tip where it borders New Mexico, just right up there on the western side is El Paso. And so, and then this white area right there is, that's Mexico. So we have a very unique geographical location. And while I will admit that the trauma that we see here based on our location is nowhere near what our brothers and sisters are experiencing in the Ukraine. And I only speak, this is me personally, not as a representative of the country or the judiciary, but you know, I wish the Ukrainian community, you know, I'm there with you, okay? Now, I am not a scholar. I'm not a researcher. I'm here talking through lived experience about what we see and hear and are exposed to in the as part of trying to administer justice in the most fairness way with dignity, integrity, and to also give access to justice. And one of the things that that is important to know is, yes, we hear horrible stories. We see kind of graphic evidence in cases, but the other thing that comes into play, it's not just about what we see in the courtroom on a daily basis. The judiciary as a whole is struggling because there are a lot of laws, both at the national level and at the state level, to erode our judicial independence. So not only do we have the daily psychological trauma or responsibility to make these tough decisions that affect human lives, we're also being watched through the laws, through new enactment of laws at the state level, because I'm an elected judge. So I want for those in Ukraine to understand, in Texas, we elect the judiciary at all levels. And so what happens is if we're faced with someone that could potentially be have committed a very serious crime, and we have this innocent until proven guilty, let's not forget, right? That's also the law. Yet we're supposed to be guided by the law that says, or we have to follow the law that says, you know, if there's certain offenses that are committed, you cannot give this individual a bond, right? And instead of having that independence to decide what type of bond is accurate and to impose certain measures or guidelines and conditions, that's being taken away. So it's like a double psychological whammy that we're experiencing. And it's tough. It's really tough. So I'll get off my soapbox for a minute. And some of the unique judicial stressors that we experience on the daily basis is isolation. Judges, we often cannot freely process the emotional difficulties that we see, or emotional difficult cases with others, because frankly, no one can believe, no one can understand what we see and what we go through. Decisional responsibility, unlike the advocates, we have to decide, and we know and we're cognizant that every one of our rulings has consequences, and sometimes the outcome doesn't feel morally satisfying, but something that Ms. Shriver identified was that, and that I try to do, is that even if, I mean, when you're a judge, you're a referee, you're a neutral arbitrator. So that means one side is not going to win. And if you are the type of person that always tries to win, which is kind of like me on the tennis court, which is where I get a lot of my activity, my stress is released, I oftentimes don't win. But so what I try to do is, and it's very important, is I try to make sure the person in front of me, no matter who or she it is, feels like they're being listened to. Really pay attention. And I have a great listening capacity. And I have a good memory as well. And so I try really hard to make sure that I explain what's going to happen because they're coming into the courtroom. The courtroom is very, very scary, quite frankly. They're nervous. They're not paying attention. I will ask them, if they have any questions. No, they'll say they understand, but yet they'll answer they don't understand. And so it's very difficult. And unlike when I'm not in the specialty court hearings with people that are suffering from mental health, and they suffer from co-occurring disorders, which is, for example, they're not on their medication for their mental health, but they are using methamphetamine, or they're drowning their sorrows with alcohol. It's very difficult, but we have to show that we're here to help them. And while the consequences aren't always going to be how they want them, or how they would like them, as long as I can show them that I have provided them with a good listening ear. I try my hardest to, make sure that they understand I'm exercising firmness versus intimidation. I try to talk to them in a respectful manner, avoid any unnecessary humiliation. And like I said, explaining the outcome is always very, very important. And research has shown that individuals are more likely to accept the outcomes, even if it's adverse to them. Say they want to go home and be released from detention. But as long as they believe that they were heard, that the process was fair, that the judge was being respectful, and the decision maker was neutral, I'm not exaggerating. I will have individuals thank me after I impose a term of imprisonment, which is a little weird because at first I thought, why are you thanking me? I mean, you're going to prison for 5 years, but I think it's because I did it I hope it's because they felt that they were respected, heard, and I was fair. And I think that that's where procedural fairness becomes especially important in our trauma-affected populations, because the transparency reduces any sort of perceived threat. And our specialty courts, I would love to get into all that, but I cannot. I don't have enough time. That's where we can demonstrate that more effectively. We have more time with the individuals. We staff the cases. And just by way of example, we had an individual who was doing so well. She'd been in the program for almost 10 months, and she relapsed. But not only did she relapse, we learned that she was living 2 lives. When she'd come to court, she was extremely positive, almost a leader among the participants in the specialty court. Well, we come to find out that that's not the case. There's been horrible things going on. She hasn't been honest with the team. Her 4-year-old daughter has been left on this, wandering at the streets at 4 a.m. in the morning. And it hurts. It really hurts. And in order to not be affected by that, and one of the results of this being exposed to vicarious trauma is that sometimes I think, what am I doing wrong? Why I feel like I'm not moving the needle, not even an inch or a scintilla of an inch. I am failing at my role of helping people. And what I do with that is I allow that. I allow to feel that. I embrace it because I can't ignore it. But I try to cut it off. Like, I allow myself a certain amount of time, 5 minutes, 10 minutes, 15 minutes. And then I come back and then I try to be very pragmatic and realistic and firm. And at the end of the day, I have to exert what I call tough love. A lot of the individuals that come before the court system, nobody has ever been tough with them. They've ignored them. They haven't paid attention to them. They themselves are victims and a product of an environment where their own parents have been drug addicts or have had mental health issues or been abusive. And so you have to go into that. So, you know, that to me helps respect the process, improves both legitimacy and the courtroom functioning. I want to just in the last 2 minutes that I have, and I had a bunch of everything prepared and outlined, but hearing the comments, I just wanted to kind of go freestyle. But how I deal with the self-reflective process of self-care is and be a healthy judicial officer. It does require deliberate boundaries, and this is all what brings me peace. Okay. I'm an avid outdoor person, and even if it's just taking a moment to look at the clouds, capture the sky, the sunset, the sunrise, um, listening to the sounds of nature, the birds singing, the water flowing, taking time to just be still in the moment. Sometimes can be really hard, but I do it daily. Seeing beautiful, I live in the Southwest desert. It's called the Chihuahuan Desert. And I have a lot of cactus. And when these blooms when they start blooming, you know, to me, that's calmness, that's serenity. And then these fellows right here, the white one, my English sheepdog, and the black one, he's my lab. Now I know why really there is service dogs, emotional service dogs. I come home, these guys give me unconditional love. I mean, I have to feed them. I get that. But they ground me. They really do. And so I know not all people are animal lovers, but if you can find something, and we all do, most of my staff has dogs or a feline. And I wasn't able to do a survey of all the judges in the courthouse on how they deal. My 15 minutes is up already. Let me just, in closing, share a couple of prepared marks. The administration of justice depends not only on legal accuracy, but on human capacity. And courts actually do function through people. And if we want fair, stable, impartial courts, we must recognize, and our panelists absolutely do, that judges are not untouched by the work, but acknowledging the reality of trauma exposure does not weaken the judiciary. It strengthens judicial awareness, I wholeheartedly believe it improves courtroom practice, and ultimately reinforces public confidence in the integrity of the courts. I wish I had more time, but thank you so much.
Judge, thank you so much for that presentation and for your remarks. So last but not least, the floor is now open to Tina Madison. It's all yours, Tina.
Thank you. It's an honor being part of this panel. I appreciate being asked to be part of this. Like Judge Solis, I'm not an expert in trauma, like Dr. Shriver, but we've seen it, we've worked with it within the United States, and I'd like to share my perspective on this topic. And we do have only a few minutes left for this presentation, so I apologize if I rush through a little bit of it. I want to just acknowledge why this topic is important to me. I've been an administrator for 38 years, and one of the things I saw while managing a felony panel, the stress of the topics, the murder cases, the high conflict cases coming through our court. We, as courts, will sometimes bring behavioral health into the courts, but for the jurors, not for the court staff. And so that's where I all of a sudden became very powerful to me. What are we doing for our court staff? And so I wrote a paper on vicarious trauma called The Silent Stressor, because all of the things that the panel members have talked about. And like Judge Solis, if you don't talk about it, if you don't address it, it's there. And I think all of the panelists have talked about that we have to be people-centric, because the work of the justice system is not done in a vacuum. It's done by our court staff and the judicial officers. So overarching why, I think, again, it's kind of been covered, why we need to address it at an organizational level. It's systemic, right? It's the work that we're doing. It's the people that are coming to the court. It's the cases. And a lot of times we talk about criminal cases, we think about those murder trials, the war crimes, those things, but you think about family law. These are people's lives. There's a lot of high conflict in the family law, child welfare cases. They're not easy. And the people that are coming in have their own trauma, but our staff have to listen to that. And it's that consistency. It's the day in and day out. It doesn't stop. It just keeps coming. And so how do we address it with our teams, with our staff? And again, that's kind of the topic of this webinar, is building a trauma-informed court system. And there are really 4 key components that I want to just highly touch on. They all, each in and of themselves, could be a deeper dive, a webinar of themselves. And so the first, like Dr. Shriver started us off with, training. What is trauma? And just having our staff be aware of it, just creating some baseline training and letting our staff know this is what it is and what does it look like within yourself, that recognition. And then some steps on how to mitigate it. And I think all of us have kind of already touched on little ways to do that. I love, Judge Solis, that you had those concrete pictures of what it is that we can do internally as individuals. But as a court, we should be training our staff on that and giving them that information. But it should be mandatory. It shouldn't be a one and done. It should be across the board. The training program should really be also role-based. We have the judiciary. What they're seeing and what they're dealing with is entirely different than what court staff is dealing with. Or our security team, the people at the front, or our courtroom clerks, what they're hearing, what evidence they're looking at. So all of those are role-based. And so you need to specify your training towards each of those individual things. And then it's not a one and done training. It is a continual conversation that you're having, that you're making sure with staff that they understand. And then building in resilience training as well. Policies, making sure your HR policies, do you have employee assistance programs? Looking at what I loved that Natalia, I believe, talked about flex time, looking at your policies. How does your court operate? And building those things in, making sure that well-being is prioritized within your organization, and that your sick time, your wellness leaves, all of these things are protective. Looking at performance measures, looking at your court staff, how they're doing, how they're performing, because those are indicators, as Dr. Shriver talked about, could be indicators into what they're experiencing, what they're going through. Operational strategies. There are so many different ways we can look at this from a court organization. You can look at it from the caseloads, and I believe Natalia talked about how just their cases have exploded and there's so many of them. How do you manage those caseloads? For me as an administrator, I would look at high volume courts and high stressor caseloads like domestic violence, or even in evictions, and making sure that the court staff maybe are rotated. So that way they're not consistently bombarded with that, and building that strategy into your caseloads as well. Maybe, and I don't know if it's possible in the Ukraine, but looking at our caseloads and managing them, can you put a cap on how many cases are being heard each day? Or finding some ways to triage the cases before they come to the courtroom. Those are some operational strategies you can do, but also your physical environment. And I can't speak to what's happening in the Ukraine, and just hearing what you guys are going through, it has caused me stress. Just knowing that sirens going off, that obviously is going to have an impact. But our physical environment for our court staff, do they have break rooms? Do they have that safe location to decompress? Do they have times where they can just step out of the courtroom? Do they have a way to call somebody and say, can somebody cover, because I can't deal with this hearing? And having that in your operational plan. I heard standard operational procedures. Building those things into your court's organization is very important. I love that the judge talked about, what the judges go through, but making sure the judges also have all of this knowledge as well, because some of the operational strategies might be explaining to the judges how they run their calendar also can impact the staff. So, if they're running through it, or the judges are, going super fast that the staff can't keep up, that could be a stressor as well. So just keeping that in mind. Again, flex time was also mentioned. I thought that was a good operational study, making sure either flex time hours or days off, even finding ways to do that as an organization. And then finally, support structures. I love that the judge mentioned that sometimes, judicial officers have to consume this information, think about it, make decisions, and they really don't have anybody to talk to about that. They might have other peer judges that they can go to, but what about our line staff? What kind of supports are we offering to them? And we do have employee assistance programs, but in every court that I've worked in, and I've worked in several, I don't see that employee assistance programs being utilized to their actual, why they're there. They're there to help people with their lives, with the things that are going on with them. And so how can we promote those? Can we provide classes on what do those employee programs, assistant programs mean? And then also take away some of the stigma of those, because even reaching out for assistance can sometimes, staff are afraid to do that. And how do we make sure that it's not seen as a bad thing? We need that. Also making sure, finding ways to do a peer support program. So that's a kind of a relatively new concept, and one that's hard to really wrap our brains around, because we're not therapists, we're not counselors, we're either administrators, we're managers, but I also remember being a courtroom clerk and listening to the things that my staff had to listen to, and that empathy thing, that empathy piece, and making sure it's like just having somebody to listen to them, or a support group that they can talk about it, and have those conversations. So most of the people that, I can't go home and talk about some of these cases, because the individuals at home, they don't understand. They're not there. They don't get it. Where all of us working in this court environment, we get it. We know what it's like working with this information day to day. And so finding a way to create a peer support network is vital, I believe, for our court staff. But also as a support, what is leadership doing, and how is leadership supporting? And does leadership also show kind of a modeling of how we're supposed to deal with all of this? Are we a leader that sits behind the desk and doesn't talk to anybody, or we work long hours, we don't take breaks, we don't take lunch? Because then our employees look at us and say, oh, they're not taking the breaks, they're not doing this, so therefore that's what I should be doing as well. So those are some of the support structures we can put in place. Obviously, implementation and challenges of putting any of this together, finding ways to do training and all of that, it's money, time. But as we've mentioned, this is vital. We should be doing these things. Some of the metrics and measurements you can do, somebody mentioned in the chat, turnover, and how do you look at that? You need to look at numbers, and then and use that as your data. Okay, we have a lot of turnover in this area, so how do we address it? Is it the topics? And have that inform what type of training do we need? What type of information should we be maybe rotating this calendar or this docket? So using that information to sustain the initiatives. And finally, just kind of ways to implement trauma-informed and, like I said, the operational strategies, rotation of clerks, flex time. But you really need the buy-in, obviously, of your administration, your lead judges, that this is important. And we've been talking about how we're people-centric. Without the people, we can't do the work. So making sure you have those buy-ins is vital. And then try a pilot project. Try implementing some of these things across the board, and then reiterate. Again, go back to the training board, make sure people that have turned over, you have the new employees getting trained on trauma and what it looks like. And it's just kind of a rinse and repeat with a lot of this stuff. Sorry, this was very, very broad, very overview from an operational standpoint, but I want to thank everybody and thank the panel, because if we don't address this, it just doesn't disappear. So again, I have some resources in my PowerPoint. We are going to publish these online after this recording is over, and there's some resources that I've pulled from and that are available to everybody. And if there is any questions about any of these topics, I'm always happy to answer any questions. So thank you.
Wonderful, Tina. Thank you so much for that. So with that, we've come to the point of the webinar that we'll take some questions for the panelists. And so we'll start. Some of these are in Ukrainian, so perhaps some of my colleagues could assist me with respect to that. So let's go to the first question here. One of our participants asked, I've been reading a bit about how PTSD can change the brain. Has there been the advent of medical intervention / sick leave where this occurs at court? Given rules about transferring judges and their independence, is there a pathway to ensure that judges take on different areas of law where they have worked for many years in areas of law that create that PTSD and burnout? So I'll leave that open, but perhaps Judge Solis, maybe you could start us off with remarks.
Sure.
Feedback on that.
Yes. So there's really, so when you're elected as a judge in Texas, you either are elected to a family court law, or at least in El Paso, because it changes. Some jurisdictions, say in San Antonio, Texas, Austin, Texas, they have a central docket and they do everything. They do family, they preside over family law, criminal law, civil law, probate, juvenile. Here in El Paso, it's more nuanced and specialized. So we break it up into juvenile courts, family law courts, and to be honest, I'm very grateful that I am not a family court law judge. That's where a lot of emotions go back and forth, right? You can only imagine. Then there's some judges are just civil cases only, where there's no deprivation of liberty at stake. It's all money, which, and I do both. I'm a court of general jurisdiction. So when things get tough on the criminal side, I actually have a little bit of reprieve or respite on civil cases when I have my civil docket. But I will tell you that some of the civil cases, like the injury cases, wrongful death by suicide case, I just had to issue an order on the saddest case. and it was against a university, and the government. It was a state entity, and they had, of course, sovereign immunity. And it was a medical student, and he committed suicide because of some disciplinary actions that were taken. And I mean, woe was me having to make the tough ruling. I tried all my might to find out a way to keep that case alive, but I couldn't. So sometimes, because I followed the law, but sometimes, the civil cases can be just as psychologically traumatic as the criminal cases. And real quickly, I wanted to follow up on Tina's comment, is that what I do as a judicial leader, one of the things is that my staff, there's only 3 of us, we make sure we have lunch every Friday together. And if we're not in trial, and and we talk, and it's the highlight of my week, quite frankly. And when I'm either traveling or I can't go because I have a luncheon meeting or something, I miss that. So maybe we try to go on a Thursday. And then the other thing is what I put up there as in my little graphic collage of what helps me, try to remain calm and reset. All my staff, and then the team for the specialty court, they rely on their family. They are able to family exercise. The humor, very important. You have to be able to laugh. One of the things that I was taught when I got on the bench was you have to be able to laugh at yourself. And I'm very serious. Contrary to my personality, I'm very serious inside. I want to get it right. I want to help people. And when I can't, it depresses me. But you do have to laugh at yourself. And I have a judges book club where we just poof, it's so you don't realize that support that's needed.
Very good, Judge. Thank you so much for that.
I don't know if that answered, but that's for the record. I'm gonna leave it at that.
Right. So I want to open this up to the other panelists, Dr. Shriver, Dr. Carol, Tina, anyone who could potentially speak to other points with regard to the PTSD question.
I can jump in there, Joe. I think it's a really good question, and I know that a number of courts in Australia are thinking about how to grapple with that question at the organisational level. There are some courts, so in Australia, we've got a three-level court system within our states, and the intermediate court hears all the indictable sex offences, many of which are child sex offences. And so a number of those courts are looking at ways of tracking how many of those most disturbing cases a judge has heard in a row before they ensure that the judge is hearing a different kind of matter. And other courts are doing similar things. So that is recognising that there are certain cases that most people find the most disturbing, and trying to make sure that that is equitably distributed with some breaks built in. So it's not just kind of down to chance. And I think this really goes to Tina's point about thinking about what can we do in terms of policy with a bit of thought and oversight to mitigate or prevent some of the unnecessary sources of exposure and pressure that judges and court staff face. And I'm certainly aware that that's happening in Australia.
Wonderful. Thank you, Carly. So Natalia, any other additional thoughts? Particularly because for obvious reasons in terms of what's going on in Ukraine. I'm sure you're feeling the sort of acute impact, if you will, of what's going on there with the PTSD.
Я бачу, що ми трошечки виходимо за таймінг, але все ж таки дуже
I can see that we are slightly behind the schedule, but I would like to catch this opportunity and to have a small discussion. So speaking of the situation in Ukraine, it's been very interesting to learn the US experience where there is this repartition into domestic violence cases, family cases. So this is particularly relevant for us. In Ukraine, we do have specialization for judges to a certain extent. There are so-called juvenile judges in Ukraine. Such judges are elected by the session of all judges of a court for the period of 3 years. However, the idea of rotation is indeed a very good idea, and it's something which should probably be implemented in Ukraine, even though there are obvious obstacles nowadays. Because we are lacking judges. We're lacking judges who are eligible to be juvenile judges, because a potential candidate should have at least 10 years of experience as a judge. In the meantime, there is understanding that specialization is needed, especially when it comes to sensitive cases. So the juvenile judges were the first comers and the first runners, and now there are pilot projects on specialization in family cases, for example. Now, referring back to what Tina pointed at, I fully agree that some recovery should be provided for judges who are constantly exposed to trauma. In Ukraine, it is, however, challenging because of the above-mentioned factors. Thank you.
Okay, thank you. So we have time for one more point that sort of a follow-up to with respect to the judges, but I'll hand this actually over to Tina. It's the same kind of question, but it relates to the staff. So anything you could add as sort of a final thoughts to wrap this up, Tina, with respect to the same question, but instead of addressing it just for the bench, how it relates to the court staff.
Of course. I kind of put in the chat a little bit. You can take surveys on staff. Dr. Shriver had a traumatic kind of a survey and see where your staff are at, and then utilize that to kind of inform you as an administrator if you're able to rotate. I know historically a lot of judges don't like their staff to rotate. In some situations, like Judge Solis, she's an elected official, she gets to pick her staff. So as an administrator, you can't really rotate. But in Arizona and California, I know that the administrators have control over the courtroom staff, so they can rotate. And so, but you do want consistency in the courtroom. You want to make sure that the judges are being supported and they have trained staff. And sometimes it becomes a personality preference, but you have to oversee that. You have to get past that, and it has to be for the best interest of the staff and making sure that they're not getting burnt out, that they're not getting exposed day in and day out, and using that data from those trauma surveys, court staff satisfaction surveys, saying, yes, I'm feeling these things. And that's the indicator, and then use that to develop your policy for rotation. It's difficult because, like I said, our court systems are very formalized, very structured, and judges like their staff to be with them. But in reality, we have to look at these things.
Excellent. Thank you so much, Tina. So just I'll close with just a couple of remarks here with respect to everything. Okay, so with that, I know there are some additional questions that some of our panelists have taken the opportunity to respond to directly, but I want to thank all of our panelists for their insightful, thoughtful presentations. And of course, I thank our participants for joining us from across the globe. I know the time schedule is what it is, so some of you are with us at this sort of odd hour. So today's discussion really kind of highlighted an important reality. And that reality is that trauma is not a peripheral to the work of the courts. It's actually oftentimes embedded within it just because of the nature of what we do. And so whether you're considering the experience of litigants, victims, judicial officers, court staff, attorneys, justice partners, understanding the impact that trauma is really essential to ensuring that the institution of justice remains effective, it remains fair, it's responsive to the community. And so we heard about the psychological foundations of traumatic stress, the challenges faced by judges who routinely encounter all of these difficult human experiences, and the extraordinary resilience that's demonstrated by the courts operating under the wartime conditions that were spoken to about from our colleagues there in Ukraine. And really also the leadership strategies, right? The management and the administration that's necessary to creating that supportive and sustainable court workplaces. And for those of you who are interested, there were some questions related to the impact of PTSD and the change that occurs in the body and in the brain. I would, apart from the expertise that was shared today, some of the literature that I'll share with you is that I've studied and written about and published about is the work of Bessel van der Kolk, wrote the book The Body Keeps the Score. Other work by Dr. Vincent Felitti, who was the pioneer in the groundbreaking research of the ACEs, the adverse childhood experiences, in response to some of those questions. And so, while the circumstances today may differ, obviously, across all the different jurisdictions where we come from, the underlying message is a universal one, and that is the courts function the best when they recognize and take a purposeful attempt to address the human dimensions of justice administration, because that's who we're dealing with, human beings. And so on behalf of the International Association of Court Administration, I'd like to express our sincere appreciation first and foremost to our president, Pam Harris, our partners at Pravo-Justice, Maxim Pepura, Oksana Sembriska. I appreciate you. Of course, our distinguished panelists, Dr. Carly Shriver, Dr. Natalie Corral, the Honorable Selena Solis, my esteemed colleague, Tina Madison, for sharing your expertise, for taking the time and sharing that expertise with us, sharing your experiences with us. And of course, we're also, grateful to each of you, our fans, for your participation and for the important work you do every day in the service of justice. We encourage you to continue. I encourage you to continue these conversations within your own courts. And hopefully we've given you some foundation in which to develop that conversation throughout each of your organizations. And most importantly, to remain engaged with the educational programs, the resources that are offered by a litany of organizations, but specifically here, us at IACA and our partner organizations. So thank you again for joining us. We wish you a splendid, productive day, evening, or morning, wherever you find yourself in the world. And we look forward to seeing you again at future IACA programs. Thank you, and have a pleasant day.